show on the road. Good afternoon. This is House Judiciary Committee. It is the 6th, still the 6th of March. Yeah, 2025. We're going to go through a voting list here, and we have an absolute hard stop at 4 o'clock. So much after 3:45, I'm going to start making a decision. Before we begin, however, for Monday, I think it's the criminal law subcommittee is at 10. Yeah. Civil is at 10. Okay, the bottom line is at 10, 11, 12, and 1, there will be subcommittee hearings. I think it's civil, criminal, public safety, family. 10, 11, 12, and 1. Civil, criminal, public safety, family. Followed by a voting session at 2 o'clock on Monday. On Tuesday, we're expecting to have double sessions on the floor. And for those of us new to our show, you'll take notes from a friend. But I anticipate.
Yeah, bring snacks.
Tuesday, we're anticipating double session on Tuesday. The reason I mentioned that is because there will be also a bill hearing for 12 bills on Tuesday. In between those two sessions, there's a possibility for a voting session after that, depending on when the bill sessions are and depending on when we're expected to go back to the floor. So you should definitely wear clothes. You should 100% bring your clothes for Wednesday if you're coming back and forth. You should absolutely do that. Yes. Yes. Okay. Well, this is starting well, so I appreciate it. We'll go to the list. I'm going to hold House Bill 238 as there appears to be an attempt by another bill sponsor to lop on 40 different bills onto House Bill 238. So we're trying to figure out what's going on. House Bill 259 is next. There's a amendment. Slow your roll. We got an amendment here for 259.
Move the amendment.
It's a motion for the amendment and a second. Can we hear what the amendment does, please? Here comes Claire.
Here comes Claire.
The amendment basically reflects what the Senate did. The Senate's already passed this bill, but there is a language change. We had to tweak some of the language to correct a drafting error, but the Senate staff has agreed to it. So it's basically just conforming the bill to the Senate. And so what it does is it creates an exception for citizen-initiated charges and reduces the maximum fine from $10,000 to $1,000.
Are there any questions for council?
Yeah, this is 259.
On the amendment, any further questions on the amendment? Okay, seeing none, all in favor of the amendment, raise your hands. 2, 3, 4, 5, 6, 7, 8, 9, 10. Anybody opposed? Seeing none. All right, the amendment is adopted, and now we're on the bill as amended. There's a motion for a favorable and a second. Any further conversation or about the bill as amended? Delegate Arcand.
Can she just come back and now tell us with the new amendment, sort of like
Claire, can you come back and just review what the bill does as amended, please?
So this is basically, this is a departmental bill requested by the Department of State Police. It's basically a housekeeping type of bill relating to the DNA database system. It alters the circumstances in which a DNA sample must be collected and stored in the statewide DNA database system, alters the individuals required to collect the DNA samples, and alters the process for collecting the samples, clarifies when a DNA sample may be tested, placed in the database system, or destroyed and expunged.
Was there any
see.
opposition to this, Bill?
Delegate Moon.
So just a brief, like, plain language here, because we had this bill last year, and we did a fairly quick review on this, but I went back through the old testimony, and basically, the current DNA collection for people who are arrested or convicted uses language like, based on the date of arraignment, but it's undefined
Okay,
in
that's right.
law.
Yep.
And so they wanted to use terminology that is clear. And what's happening now is they have to rely on AG advice as to whether they can test a sample or not, and it's just
Okay.
not feasible. So there's 13,000 DNA samples that are in limbo, and
Okay.
this will clear it up.
All right, awesome. Have we moved favorable on the bill? Okay.
Further questions now on the bill as amended? Vice Chair.
So one quick question, does the bill still make the refusal to give a DNA sample a crime? Is that still there? Yes. Okay, thanks.
All right, seeing none, the Vice Chair.
Yes.
Yes. Valentine.
Yes.
Yes. Crutchfield.
Yes.
Yes. Cardin. Yes. Tomlinson. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Stinnett. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Sample Hughes. Yes. Moon. Yes. Conaway.
Yes, I was asked, can you amend on it?
You could, do you want to amend on it? Conaway amends on. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. All right. Bill's favor motion is adopted. Now let's go to House Bill 438. In the sordid history of House Bill 438, a suggestion was made, and there was an amendment that was maybe going to be offered, but maybe not now, to change the number from 25,000 to 20,000. Then JPR decided to go ahead and move the bill at 25,000. So basically, Madam Vice Chair, what's your pleasure?
Move the bill.
There's a motion for a favorable. There's a second.
We do have the title change, and JPR is okay if you want to add Betty's law to it.
Yeah.
They were sent that.
Yeah, so I have that too. So there are two amendments. Well, so we do have one amendment that there's,
So what do you think?
okay, so here's what we're doing. So the sort of the more important question in our work here is whether it should be either $20,000 or $25,000. And I believe the Vice Chair is fine leaving it at $25,000, which is also where the Senate put their bill as they passed it. However, they also put another amendment on it that called it Buddy's Law. They named the bill.
They didn't,
No, they
name it,
didn't.
but they're okay with it. They just didn't do it. But they should.
Wait, so they didn't do it? Oh, they didn't do it. So we could pass this clean.
You could.
We could pass it clean. Well, now that I've confused everybody, there is. All right, so let's go to what the bill. All right, wait a minute. Okay, we're gonna, too much cross traffic. Do you have a motion?
I have a question.
You have a question. All right, go with the question.
So let's just say hypothetically, we moved out the bill with the amendment. Perhaps maybe Holly can explain, or either the chair could explain, what would happen to the House bill? So if we put in the amendment of Buddy's Law,
It would go to the House and then they can pass it back and just conform with the change.
And,
We could add Buddy's Law, to the bill. They could just concur with our amendment and be done.
I move the amendment for Buddy's Law as the title, please.
This,
We can do that part.
She can do that. It's been moved and seconded. Is there discussion?
it's been moved and seconded. Is there discussion on its amendment 103925? Delegate Moon.
Number one, who's Buddy? And, no, I'm serious. And number two, is Buddy worth making the bills different? Not to say that someone's Buddy isn't worth making the bills different, but I asked the question whether there's,
He owns cast, is why this happened.
So I'd be happy.
Madam Vice Chair.
I'd be happy to answer that question. So, the bill as passed the bill as introduced has always had the title Buddy's Law. There was a drafting error, I like the way that sounds, that did not include Buddy's Law in the title. So, the person who who brought this bill to me years ago was always called Buddy's Law. So it was an inadvertent error not to bring that name into the title. Buddy belonged to Mr. Lawrence Sanders, and he is the impetus behind the bill, because Buddy was injured because someone shot him. So that's the deal.
Delegate Conaway.
Thank you. On the amendment, so the penalty would be what, on the amendment, 20,000?
The maximum of, okay, so on the bill, in the bill right now, what it does is it changes the maximum amount you can get for the death or serious injury of a pet. It would raise it from $10,000 to $25,000.
Yes. And can I just explain?
The Vice Chair.
Can I just explain? This is not a criminal bill. This is a civil bill. So if someone else injured your pet, you can claim, in your complaint, you can be awarded up to $25,000. Okay, that's all it is. This is not any penalty per se. It's just, because it's not a criminal bill. This is a civil bill.
Delegate Conaway.
Horse be considered, could you have a horse as a pet?
A horse is a horse, of course.
Thank you.
It could be, it does not include livestock, so no. No, horses and livestock are not included. Delegate Tolles.
I just wanted to know who Buddy was, so that's been answered.
All right,
Thank
so
you.
we're on the amendment as to whether to make this Buddy's Law. We've had plenty of conversation about this, and I don't think I can stand any more of it. So if you want Buddy's name attached, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. All right, everybody's for it. Nobody against it? Doesn't look like it. Great.
Thank you.
So we've added the amendment that this is Buddy's Law. The bill, as it's introduced, would make it $25,000 up from $10,000. There's a motion for a favorable. Is there a second? All right. We're now on the bill as amended to make it Buddy's Law. Buddy? Anybody else? Questions on the bill?
You've already amended the first amendment. Oh my God, depends on how they identify.
It's fine. No, I've just decided that when I start to have my head spinning around when we're arguing about these things, I'm just going to repeat, I love each and every one of you deeply. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Carden?
Buddy, yes.
Oh, God. Tomlinson? Yes. Embry? Yes. Pasteur?
Pastor?
Yes. Tolles? Yes. Schmidt? Yes, and add. Simmons? Yes. Boucher? Yes. Phillips is not there. Stinnett? Yes and add. Congolo? Yes. Erican? Yes and add. Taylor? Yes. Simpson? Yes and an add. Grammer? Yes. Sample Hughes? Yes and add. Moon? Yes. Conaway? No. Kaufman? Yes and an add. Williams?
Yes and an add.
Yes and an add. Cardin adds. Going once. All right. Our long national nightmare is over, and we can proceed now to, he's not here, so we're not going to do 592 right now. And so now back to our good friends at, well, he is here. House Bill 592. Are you okay? On buddies, yes. Yes, all right. Phillips votes yes. Yes, and an add to Buddy's Law. All right, kind of, 592. 592. There are no amendments. There's a motion for a favorable and a second. All right. Delegate Phillips, would you remind the group what this bill does?
All right. Assisted outpatient treatment is a bill that passed in HGO in 2024. The whole objective was to set up a mechanism for court-ordered assistance that would be done outpatient. The Psychiatric Association had requested, and it won't be implemented actually fully until 2026. There is a pilot going on. The Psychiatric Association said, hey, we've got these people that will be in, this is assisted outpatient treatment, and they would be potentially of harm to themselves and to others. It's a relatively small group of individuals, but we believe that they should be placed on the prohibited persons registry. And so that's what this bill does.
Motion and second on the bill. Are there questions for the bill? It's very quiet. Hearing no questions, the vice chair.
Yes.
Yes. Valentine? No. No. Crutchfield? Yes. Yes. Cardin? Yes. Yes. Tomlinson? No. No. Embry? Yes. Pasteur? Yes. Yes. Tolles? Yes. Schmidt? No. No. Simmons? Yes. Yes. Boucher? No. No. Phillips? Yes. Yes. Stinnett? Yes. Yes. Congolo? No. Erican? No. Taylor? Yes. Simpson? Yes. Yes. Grammer? No. Sample Hughes? No. Moon? Yes. Yes. Conaway? No. No. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. One moment, please. 14 votes. Motion is adopted. Okay, now back to the never-ending saga of House Bill 623. When we last left our episode, Delegate Conaway was about to make a statement, and so may do so now, but has to turn on his mic. There we go. You're good.
Thank you, Mr. Chair.
Yeah.
I just wanted to say that it might be a level of difficulty in certain people's families when they come forward and identify themselves as being an unknown child, and that, I don't want to say it's common in my community, but I am aware of situations where that does happen frequently, so I just wanted to say that.
So you're concerned about people who find it difficult to come forward? I'm connecting it to the amendment. You're concerned that
we were talking about just having it on the Register of Wills site versus having it in the smaller
Yeah, the
papers.
Register of Will site versus the newspapers.
Yes, and this change of, I mean, I don't even go to the Register of Wills site to see
Okay.
who did what, but I do look in the Sun and other papers to see what's going on, so.
Okay. We're on the amendment. Again, the amendment is the, what we'll call the halfway amendment, I guess. Delegate Embry.
I just wanted to say that I'm convinced by those who've argued for an incremental approach, and I appreciate the wisdom of that, so I will be voting for Delegate Moon's amendment.
All right. I know. So the bill sponsor supports the Cardin, or was it the Moon amendment? It was the Moon amendment? Let's blame David. All right, David. We already are on the amendment was moved and seconded. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. Anybody opposed? 1, 2, 3, 4, 5, 6. The amendment is adopted. We're on the bill as amended. And now Delegate Tolles and then Grammer.
I'm sorry, I don't want to dig for, wasting time digging for. What is the Moon Amendment?
The Moon amendment, go ahead, Delegate Cardin.
So the bill would have required,
No,
instead
just
of.
give me because remember, I'm on civil procedure, so the short version.
We had to, the bill would have published
I just can't
everything on the Register of Wills website instead of requiring it to be published in newspapers. What the amendment did is said that only certain ones would be required to be on the.
Is that the heirs that people don't know? Okay.
Spouse, registered domestic partner, lineal ancestry, or lineal descendantry. Those are the only ones. If they're known, if those heirs are known, they can just do it directly on the Register of Wills. If they're not known, then they have to be published. How's
So
that
then my follow-up is, okay, never mind. Okay, all right. Wait, he had a.
Delegate Grammer.
Thank you, Mr. Chair. I have an idea for an amendment in principle, if it's at the pleasure of the chair. I think now that we've required this kind of incremental step, would it be okay to ask the registers for each county to report how many people have been identified via this process? We could write some language in, simple reporting thing, and then that way every year we could look at this and say, how many are we actually seeing? If it's at the pleasure of the council.
That sounds right. Second. We're amending it anyways, we could add it.
We're amending it anyway.
It's a reporting.
Amendment, we have time.
Yeah.
Bill sponsor, Delegate Embry.
Thank you much.
We'll hold it one more time, and we note that Delegate Conway also was waiting to speak again, so we'll get the first time for next time. But I'm going to ask you, Delegate Grammer, to draft it so that we can do it on Tuesday, all right? We're holding this bill again. It's great. Well, it's already been vetoed once. Let's see what happens next. All right. Uh-huh. All right, House Bill 775.
Move favorable.
There's a motion for a favorable and a second. All right, this is Delegate Otto's bill that says that if you live in a jurisdiction where there is a Department of Corrections facility and someone dies within the facility, that notice is sent to the state delegates and senator of the legislative district where the facility is located, and then the chief executive of the county where they're located, and that would be the mayor or whichever county executive version you have, depending on where you live. That is what the bill does. There's a motion and a second. Discussion on the bill. So this won't necessarily impact everybody in this room, but it'll impact some people in this room. Delegate Taylor.
Although it won't really impact me, really. I just wonder, once we get that information, what are we expected to do with it? Or is there any expectation that we will do something about it?
I mean, some people might argue that it would be one way for us to be more aware of what's going on within.
Just an
within
awareness.
correctional institutions, and that it would be helpful for people to actually know when these things happen. Delegate Otto's point was, I have people who come up to me and ask me what's going on and why, and this person died, and he didn't know what was going on with that person, or what happened with that person. Again, I think there is actually some redeeming character, not that it doesn't have redeeming characteristics. It is redeeming in a way that if it does draw more attention to when people are dying at our facilities, I don't think that that is necessarily a bad idea. Delegate Valentine.
And I was just going to add, Mr. Chair, thank you, the same sentiments. Having 3 state correctional facilities in my district, that does come up from time to time with my constituents reaching out to me. And Delegate Otto and I spoke about this. So.
Delegate Simmons.
Thank you, Mr. Chair, and I would concur. Our correctional facilities, obviously, we're moving a lot of legislation around the support of those institutions and what's taking place there. Situational awareness is our primary responsibility, making sure that we're accountable to what's taking place in these establishments when it comes to our constituents. It also has a reentry factor to it of folks that are coming out of the system as well, knowing what's going on in it. So I encourage all my colleagues, those who have not been on a tour of any of our correctional facilities, to get in there and understand what's taking place.
Delegate Sample Hughes and Erica.
Sure. Thank you, Mr. Chair. I would just reiterate that the importance of the bill is certainly for us to be aware, and we should. ECI is located in our jurisdiction, and which is a large facility. And oftentimes when someone is killed in the prison, it's on the local news. And so that just escalates the inquiry, but it also speaks to the fact that staffing is a huge issue at ECI, and I certainly know across the state. And so we're always, as legislators, advocating and going to these workshops that Department of Public Safety puts on to try to get people to become correctional officers. But then we also get the side of the staff that are fearful to work in facilities that are not properly staffed. So it's like a whole lot of information, but being aware at least is beneficial as a state legislator.
Delegate Erica.
Yeah, I just wanted to add that, I listened to the bill hearing, but the real testimony came a couple of days later with the mother who talked about what happened to her child. I mean, that testimony alone, I think this bill and maybe even an expanded version of it next year, I mean, we, at least on this committee in JPR, I think should also be receiving notices. I'd like to see an email every time something like this happens, because that testimony was so disturbing, I could barely sleep, so.
At the moment, looking around the room, I think that it would, first of all, it's 1, 2, 3, right out of the gate, the Baltimore City Detention Center, Jessup, and then Hagerstown, MCDTC, yeah. So Roxbury, right. So, I mean, others may have facilities in other parts of the state, but I think it's a place to start. So with that, it was moved and seconded. Is there any further questions? Thoughts? Seeing none on House Bill 775. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin? Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? I'm sorry? Yes. Yeah. Okay. I heard Tolles, yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Dinette? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right. Okay. That's 775. Now we're going to Delegate Crutchfield's bill, 1060, and there's no amendments to 1060.
Not favorable.
Is there amendments? Wait, there are amendments. Oops, sorry. Delegate Crutchfield, do you want to tell us what the amendments do?
Yeah, the amendments just bring
Bill, I'm sorry. Oops. Yes, the amendments, thank you, Mr. Chair. The amendments just actually bring the bill back to the form where it now is clearly stating some of the terms, such as honorable discharge is put back in, and just lining it back up the way it actually needed to be to meet the federal terms. That is what the bill really does. The bill really just makes sure that instead of using the term armed forces, we're now using uniformed services to indicate all of the military branches as one definition.
All right, motion on the amendments. There's a motion and a second. All right, any further discussion on the amendments? Seeing none. All right, all in favor of the amendments, raise your hands. Anybody opposed? Seeing none, the amendments are adopted. There's a motion for the bill. Is there a second?
Yes.
Motion for a favorable and second, okay. All right, we're on the bill as amended. Any further conversation about the bill as amended? Seeing none, the vice chair?
Yes.
Yes, Valentine?
Yes.
Yes, Crutchfield?
Yes.
Yes, Cardin? Yes, Tomlinson? Yes, Embry? Yes, Pasteur? Yes, Tolles? Yes, Schmidt? Yes, Simmons? Yes, Boucher? Yes, Phillips? Yes, Stinnett? Yes, Congolo? Yes, Erican? Yes, Taylor? Yes, Simpson? Yes, Grammer? Yes, Sample Hughes? Yes, Moon? Yes, Conaway? Yes, Kaufman? Yes, Williams? Yes, all right. What? Yeah, I mean, we're going to talk about it for a minute, but I'm going to get. Kaufman wants to add to 1060. Kaufman is added to 1060. Going to hold for a moment on 1123. We're not going to vote on 1123 today, but we are going to have a conversation, and then we'll have a vote on Monday, hopefully on 1123. The last, well, we'll see if it's the last. House Bill 1440 is Delegate Robin Lewis's bill on lactation. There's an amendment. There's an amendment. Okay, and the amendment does two things. There was conversation with the judiciary regarding this bill, and their concerns did not, there's two things that the bill does as it was introduced. First, the bill indicates that if there is going to be a major renovation of a circuit courthouse on or after October 1st of 25, the circuit courthouse shall maintain on its premises a private lactation room that can be used by employees of the court and members of the public to nurse and express breast milk. Many of their facilities have one, not all of them do, so the idea would be if they build a new circuit courthouse, then there would be, they would be required to have a lactation room. And from the testimony and the contact that I've had from people in my district and from around the state, the issue is with people who are on jury duty needing a place to go. So that part of the bill they didn't have a problem with. The question that they had was with regard to a blanket automatic excusal for certain individuals. So after talking to the sponsor, we have an amendment that, Holly, would you describe the amendment, please? It does the amendment does two things.
So the First Amendment alters the age of a child from a child younger than 4 years old to younger than 3 years old. And this is the age of the child for if they require continuous care, then that's also a reason you could ask for an excusal. And then the Second Amendment clarifies that a jury judge or jury commissioner may excuse an individual who is breastfeeding or has legal custody of a child younger than 3, not 4, we're lowering that, requiring care during normal court hours. But the jury judge or jury commissioner is not required to excuse them or disqualify them.
So there are a number of different reasons that a jury commissioner can, but doesn't have to, allow someone to be excused from jury duty. So this would put it into that category where they can excuse them if someone requests it. And that is okay with the sponsor of the bill. So on the amendment. There's a motion on the amendment and a second. All right, on the amendment, is there discussion? Any questions on the amendment? No? All right, all in favor of the amendment, raise your hands. Anybody opposed? All right, we're on the bill as amended. There's a motion for a favorable.
Second.
Okay. We're on the bill as amended. There was a motion and a second on the bill as amended. Are there any questions regarding the bill as amended? Okay. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Dinette? Yes. Congolo? Yes. Erican? Yes and an add. Taylor? Yes and an add. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes and an add. Kaufman? Yes and an add. Williams? Yes and an add. Anybody else want to add? Simmons? Seeing, and Stinnett? Seeing no one else. All right, that's House Bill 1440. For the next about 10 minutes or so, we're going to talk briefly about House Bill 1123, which is medical and elder parole. I'm sorry? Oh, we need to do the withdrawns. I'm sorry. So there are a number of bills that are withdrawns. All right, so those bills are House Bill 122, 186, 198, 916, 928, and 1188. There's a motion for an unfavorable withdrawn. All those in favor of the unfavorable withdrawn, please raise your hands. Anybody opposed to the unfavorable withdrawn? Seeing none, they are in fact withdrawn. Now back to House Bill 1123 for a few minutes. The Vice Chair, would you like to give an overview of what, there will be amendments on this bill. Can you give an overview as to what the amendments do, or how would you like to begin?
I can begin.
Good.
And if I leave anything out, then we have folks who can help me out. So the amendment that you see before you that you got from in the email would add the section from House Bill 190 that speaks to improving the situations for someone who's seeking medical parole. So it goes into an explanation and defines medical parole a little bit better, what state you have to, what state of your illness, and also kind of just fine tuning the medical parole section aspects. It still would, because 1123 already had it in, that the governor would be out of the consideration for medical parole. So that's what the amendment does. And then that's it. That's what the amendment does. It just adds in the language from House Bill 190 into 1123 with respect to medical parole.
So it makes it more specific, and it addresses some of the issues that need to, that they identified in House Bill 180 that provides a little more depth and substance to the medical parole process. Delegate Moon.
Thank you, Mr. Chair. Did I see in the papers that the Senate has started moving their versions of these bills?
Yes, I believe so, yes.
And do we know how what they have done is different than what you are proposing to do?
So the difference is that in this bill, as amended, I believe that the medical parole side, okay, so just to be clear, part of the bill is removing the governor from the process of medical parole. We already removed the governor from the process for parole generally. This is another step. Medical parole, they have to do even more in order to even get to that point. And so we remove him from that process as well. The second part of the bill, at least in the House, says that we would take $1 million from the Justice Reinvestment Fund, and we would use that money to hire 2 case examiners to begin to look at people who were 60 years old or older and had served at least 20 years of incarceration. With an eye towards having those cases looked at again. Right now, you may have remembered from one of the parole bills that we heard that they have one person who does this work. We would be seeking to triple that to 3, so that they could not only clear a backlog, but they could have more people that could put more eyes on some of the people who are the oldest and who have been there the longest. So that's what this bill would do. The Senate bill, I'm not exactly sure. I know they have a bill that is medical and geriatric parole, and that creates a new system altogether. And so at this point, we're kind of sending over our version, they're sending over their version, and I think it's still going to be a work in progress as we go through the next several weeks of session. The Vice Chair.
And just want to add that there is no version of this over in the Senate. So I haven't seen what their amendments were, but there isn't a version of this over there right now, because it wasn't cross-filed.
Okay.
Delegate Taylor.
Thank you, Mr. Chair. So what does that do with House Bill 190, essentially? Does it go away? Does it become withdrawn? The entire?
Yes.
Okay, so that was all that it did was?
Right, it was all, the one consistency that was in 190, 311, and 1143 was the medical parole consideration and getting the governor out. So all 190 did was remove the governor from the decision-making process for medical parole. That kind of became the well.
Great. But it also had a geriatric in its title. That didn't?
3 bills, actually.
Let's go back. I'm sorry.
Yeah, the Vice Chair has 3 bills.
Yeah, so 190, my apology. 190 got folded into House Bill 1123. So 190 went into, you're right, it was medical and geriatric. 190 had specific information on medical parole. We took that information from 190 and put it in 1123. Okay. And so hopefully that answers your question. So that's what happened with 190.
Okay.
I was thinking you were asking about 311, but you were asking about.
No, I
The
wasn't.
third bill that is out there has a geriatric parole element to it. So we're not doing anything with that right now. We're moving this bill in part because it doesn't have a Senate crossfile. Delegate Carton.
Thank you, Mr. Chair. Just 2 quick questions. First of all, if the commission or the person who's looking at this decides that there is a safety risk, they still have the ability to deny. It's not an automatic.
No.
Okay, that's not.
No, it's just the case examiner who would be, there is a backlog of people who are looking at those people at the upper end of the age range. There's a backlog of people who are waiting to have their cases evaluated. The idea here is to be able to go through those cases a little faster, focusing on those people who are over 60 and who have been in jail for 20 years. It doesn't stop them. They can review it and say no.
There's no percent, okay.
Yeah.
And then has the State's Attorneys Association chimed in on the amendment, on the amended bill?
I don't know.
They have not.
Okay. All right, those are my 2 questions.
Yeah, I don't know.
Do you want to talk about this part yet? The victim?
So there is another amendment that I don't think the committee has. And so we will discuss this other amendment that is out there that was raised by MCASA we will do that when we come back on Monday. But it has to do with reporting requirements and making sure that victims are aware of what's going on down the line. And so we could talk about that on Monday. I'm not going to entertain any motions or anything on either of the, well, certainly not on the second one, but definitely not on the first one right now because of what time it is. And we're just not going to be able to actually get to it today. Any other general questions regarding what we've talked about so far? Delegate Embry.
I'm sorry to be repetitive. I just want to make sure everything with regard to medical from 190 is in the amendment. Thank you. Got it.
All of 190 moves across. Yes.
All of the medical.
Medical, not
Medical,
geriatric.
correct. All right. All right, I think we're going to stop right there because it's 10 minutes to 4 and it'll give people the opportunity to get up the road. This has been the House Judiciary Committee. On Thursday, the 6th of March, we will be back with a voting session at 2 o'clock on Monday. 2 o'clock on Monday. Thank you all very much.